Contract Law Teaching Online. In the last lesson, I'll talk about the importance of contract law among other branches of law, and I talked about basic elements of any simple contract, which are offer, acceptance, consideration, intention to be legally bound, and the capacity. In this lesson, lesson 3, I'll talk about the first basic element of a simple contract, which is the offer. And it has two parts. In the first part, I'll talk about the functions of the offer in making a contract. In the second part, I'll talk about the nature and definition of the offer and about the criteria by which we can distinguish which statement is an offer and which statement is not. So let's go to the first part, which is functions of the offer. Actually, the offer plays a very significant role in a contract because it has some important functions. First, the offer outlines the subject matter of a contract by which we can determine what type of contract we are dealing with. Second, it outlines the specifications and features of the subject matter of a contract. For example, if we have a sale contract, it outlines the quality, the price, the quantity, and other features of the subject matter of a contract. Third, the offer outlines the terms and conditions of a contract, and sometimes the way for its cancellation. Fourth, it provided the way for negotiation about the contract. And sometimes this negotiation is limited by terms which are determined, which are mentioned in the offer. Fifth, the offer clarifies the intention of the offerer to reach to the contract. It clarifies how serious the offerer is. By the words that are used in the offer, we can understand exactly, we can distinguish exactly, we can determine exactly how serious this offer is. And sixth, it creates the legal obligation for the offerer. Indeed, once the offer is made, once the offer is communicated to the offeree, it may bring some obligations for the offerer as well. I'll talk about this matter later, and you will understand how it works. Now let's go to the second part about the definition and about the nature of the offer. In brief, I would say that it is sometimes said that the offer is a statement by which the offerer agrees to be bound. The offerer promises to do something or refrain from doing something in return for promise from the offeree. The offer typically includes essential terms such as price, quality, quantity, and any other important conditions that the parties must agree upon for the contract to be formed. You know that the party making the offer is called offerer, and the party to whom it is made is called the offeree. If the offer is accepted by the offeree, then we have an agreement in hand. And if either fails to do as it promised, it might amount to breach of contract. However, as it said, and as I mentioned before, not all agreements are contracts. In order to form a contract, we need more requirements, we need more elements, which are consideration, intention to be legally bound, and the capacity. So when we have offer and acceptance, certainly we have an agreement, but in order to reach a contract, we need other requirements as well. Uh, let's go further, and I want to say that there are some criteria by which we can distinguish statements which are not offer but look like them. So the problem is that how we can determine, how we can distinguish which statement is the offer and which statement is not the offer. Because as I mentioned, the offer is a statement by which the offerer is going to be prepared to be bound. So we are going to distinguish which statement is the offer and which statement is not. There are some criteria for this. First, intention to make an offer. The offerer must intend to create a legally binding agreement. If the speaks, if the speaker suggests something that, if accepted, would create a binding contract, uh, then it is likely an offer. Therefore, statements made in jest, made in anger, or without serious intent cannot be considered offer. I'll sell you my car for $1 million when the car actual value is much lower. I think I might sell my house someday. This is not a serious offer. I'll give you my entire life uh, saving for that meal. Of course, while laughing, for example. Of course, it's not a serious offer. Uh, specificity of terms. Specificity of terms means that offers typically include specific terms and conditions, outlining the essential elements of the proposed agreement, such as the price, quality, quantity, and time frame. The more specific and the more definite the terms are, the more likely it is that statement constitutes an offer. Vague or indefinite statements that lack clarity on essential terms may not be considered offers. The third criteria is about the communication. The offer must be truly communicated to the offeree. Truly communicated to the offeree. Uh, this is because the offeree must be aware of the offer and its terms to accept it. Of course, if the offeree is not completely aware what's going on, what the offer is, so cannot that offer cannot be considered as a serious offer. We just accept the offer that we are aware of it. I'll talk about this matter later, more and more. Fourth criteria is identifiable offeree, which means that the offer must be directed towards a specific person, group, or class of people who have the power to accept the offer. So, for example, if I advertise something in newspaper, in mass media, in television, in radio, it's only invitation to treat and it's not going to be considered as an offer because we have not identifiable offeree. We must exactly know who is the offeree. Okay? And fifth criteria is about the words and the sentences that are used in the offer, the language which is used in the offer. See that the language is very important. Uh, the language exactly can provide clues about whether it is an offer or merely an invitation to treat. Words such an offer, proposal, promise, uh, tend to indicate to create a legally binding agreement. Conversely, expressions like invitation to trade, invitation for bid, invitation to negotiate, I suggest this, I want to give a proposal, but so. These are not offers. These are only negotiations, the base for negotiations. So we must distinguish uh, this statement is something only for negotiation or it gives you an offer. So the languages, the words, the statements, the sentences in the offer are another criteria that we can distinguish this statement is the offer or is not. And and let me tell you something which is very very important, especially regarding uh, property transfer. See that in some cases offers may be subject to formalities or requirements prescribed by law or custom. For example, certain types of contracts, such as contracts for sale of land, sale of property, uh, involving guarantee may require uh, written documentation to be legally enforceable, and failure to adhere to such formalities may affect the validity of the offer. So, if an offer comes, for example, about selling a house, selling a car, or something like this, it must adhere to formalities. It must adhere to formalities. Lack of formalities in some cases show that this offer is not acceptable. This offer is not the offer. This statement is not the offer. So these were some criteria um, to distinguish about which statement is the offer and which statement is not the offer. We have some, of course, cases in this regard that you can refer to them. I can just refer to you uh, case of Pharmaceutical Society versus Boots, 1953. That is a case from United Kingdom, and I also recommend you to study case of Fisher versus Bell, 1961, and about Patridge versus Crittenden, 1968. These are some cases uh, about contract law and about the offer by which we can study which statement is the offer and which statement is not the offer. Okay, so this was the third lesson about the first element of a contract, which is the offer. In the next session, in the next lesson, I'll talk about other elements of a contract. Of course, still we have some um, matters about offer, but we go further to see what the next will be. Thank you very much for watching this video, and if you like this video, if you think that it is useful for you, please like it, share it, and subscribe it.